Welcome back to this final part of leases and licenses in land law. As we go through this session, we will look at not only how a lease is created, but we will also consider how it is protected. And at the very end, save the best for last, we will look at Walsh and Lonsdale, or the rule in Walsh and Lonsdale. Well, as we start out, we will consider how do you create a lease. So once you have a lease based on Street and Mountford principles, how do you create it? Well, a lease can be created by the following three ways. You can create a lease by deed, which will of course make it a legal lease. But you can create a lease by deed based on the section 54(2) of the Law of Property Act 1925. You can also create a fixed term lease or an express periodic tenancy or an implied periodic tenancy. So it can either be by deed, which makes it a legal lease, under section 54(2), which also makes it a legal lease, and under section 2 of the Law of Property Miscellaneous Provisions Act 1989, which gives you an equitable lease. As an aside, however, you can also have a lease on the basis of proprietary estoppel, and this will also be an equitable lease. Now let's look at each of these ways of creation in turn. If we start with the deed. Now, if you create a lease by deed, it makes it a legal lease. The requirements for making a lease by deed is that it must, of course, be in deed form, and that is set out in section 1 of the Law of Property Miscellaneous Provisions Act 1989. In that, it must be in writing, and it must be clear on the face of it that it is intended to be a deed, and it must be signed by the person making the deed in the presence of a witness who attests to his signature. And lastly, it must be delivered as a deed. Now, the process of the witnessing of the deed is called attestation, and the witness has to sign and date the deed. Now, the point here, of course, is that when you look at a deed and the old-fashioned way of having this red seal and all of this, that's not necessary anymore. What is necessary, though, is that on the face of it, it must be that it is a deed and follow the process of being delivered as a deed. So a lease is created as it is an estate in land, and as such, it is a terms of year absolute. And section 52(1) is therefore satisfied. So the idea of the deed is contained in the statutory provision of section 52. So there's no legal estate or interest in land will be created unless a deed is used. That is the general rule. However, section 54(2) of the Law of Property Act 1925 also provides for the creation of a legal lease. Now, this section creates an exception to section 52. Remember, section 52 says you have to have a deed in order to create a legal lease. But you can have a legal lease which is created without a deed. Let's look at how this is done. This is a quick and easy way to create a lease. And in order to create a section 54(2) lease, there are 4 conditions which must be met. The first is that the agreement can be oral or in writing, and the lease must be for a period of time of 3 years or less. That is important. What does that mean for you? It means that if you see a 3-year oral lease, it's a legal lease. If you see a 3-year written lease, it's a legal lease. If you see a 4-year written lease, it is not a legal lease unless it is by deed, which is why examiners like to use 4-year leases. Please bear that in mind. A 4-year written lease will make it an equitable lease unless that writing is a deed. So, under section 54(2), as we said, lease must be for a period of 3 years or less. The lease must take effect in possession. Now, if you go back to the introductory lecture, we did speak about, or I did speak about, a tenant going into possession immediately. Now, that is one of the requirements. You cannot have, for example, where the lease is created today and you don't go into possession for 6 months or a year. That won't work. That is not to say that once you're in possession, you can't leave for 6 years, that you can't leave for 6 months to a year. But you must take effect in possession. Again, I will remind you, possession does not mean occupation. You can be in possession, but not occupying. Just a reminder. The lease must be at the best rent which can reasonably be obtained without taking what is called a fine. And the best rent is usually the market rent. A fine, of course, is a lump sum payable at the start of a lease in consideration of a reduction in the rent. So if you have to pay a huge lump sum, I am not talking about paying, for example, the deposit. If your rent is £500 a month, but you have to pay a deposit of, say, £3,000, in order for it to be £500, that may amount to more or less there being some sort of sanction, and the courts will consider that that is a fine. Now, if we look at a fixed term lease, the lease will finish at the end of the given term. Now, this is carrying on under Section 54.2 because Section 54.2 says you can create a lease like this, and the lease can either be a fixed term lease or a periodic tenancy. A fixed term lease is where the lease will finish at the end of the given term, and a fixed term lease for 3 years or less can be created under Section 54.2. Again, if it's a fixed term lease for 4 years, it is going to need to go down the legal lease route of a deed. Now, you may also under Section 54.2 create a lease which is considered an express periodic tenancy. Now again, you still have to meet the other requirements and so on under Section 54.2. But this is where when you have a tenancy for 1 year or part of a year, which is expressly granted for a period of time which is stated to recur. So you can grant a weekly periodic tenancy, a monthly periodic tenancy, a yearly periodic tenancy. It tends not to get beyond that. And the point is, you grant it for a week, and then it is stated in the document that it will recur. So after a week, it will automatically renew. But that is stated expressly in the lease. They are granted expressly and they are tenancies because there is a relationship of landlord and tenant. They are for periods of time, whether, as I say, weekly, monthly, 6 monthly, or yearly, and they can renew themselves either automatically or either party giving notice that they want to end. Now, an implied periodic tenancy is one that is implied by operation of law. Case, of course, is Martin and Smith, and it is implied from the circumstances where a person is in occupation, for example, on a periodic basis. So as I've mentioned earlier, you can have it expressly written. But let's say you give me a monthly tenancy, but it is not expressly stated that it is to recur. But let's assume that after the month, I stay on and I pay you the rent the following month. The court says that what we have is an implied periodic tenancy because it is defined and referable to how the rent is said to be paid. So when we look at an implied periodic tenancy, it is generally where you, for example, you have a fixed term legal lease for say 10 years, which was created by deed, and the rent is paid every month. Let's say, for example, at the end of the 10-year lease, you pay a further month's rent, which is accepted by the landlord, but no new lease is signed. Well, what the courts say, or what the law says here, will arise is an implied monthly periodic tenancy. It is not the same 10-year that you had before, because remember I said it is referable to the rent that is paid. So an implied periodic tenancy may not operate where there's a lack of intention to create the legal relationship of a tenancy, and the case, of course, is Javid and Akil. How do you end a legal lease? Well, either the landlord or the tenant can end the tenancy. And when you're looking at periodic tenancies, therefore, so if it is a weekly periodic tenancy or a monthly periodic tenancy, you just simply need to give a week's notice or a month's notice. When you're looking at a yearly periodic tenancy, of course, you give half a year. The point, though, is that in any of those notices being given, if you're the landlord, you must give notice that expire at the end of a period. So let's say the person's rent is paid on the 30th of the month. You cannot then give the person notice on the 15th. Even if you gave him 1 month from the 15th of March to the 15th of April, that's not good enough. You must give him at least 1 month's notice, which expires at the end of that month. Section 2 Law of Property Miscellaneous Provisions Act provides for an equitable lease because, of course, it's in writing. And the section says that if it is in writing, signed by or on behalf of both the parties, and it contains the terms under which the parties will operate, then what you're looking at here is a contract. And because it is in written form and it is to do with land, then notwithstanding that it is not by deed, it will still create an interest. And that interest, of course, is that you have an equitable lease. Proprietary estoppel will also operate in certain circumstances, because proprietary estoppel arises where you lead somebody to do something. So you either actively encourage them to act, or you stand by knowing that they're mistaken as to their rights. Even though formalities for creating an interest have not been followed, the law will say that you're estopped from your action, especially if it is that it is unfair. Basically, you're not allowed to use a statute as a cloak for fraud. So if you stand by and allow somebody to think that they have an interest in land, and then of course you decide to engage your formal rights, the courts will not allow this to happen. So what you need is an assurance, a representation, the fact that the person has relied on it, and of course he's relied on it to his detriment, and the courts consider that it is unconscionable in all of the circumstances. How then do you protect a lease? Well, in unregistered and registered land, it is dealt with differently. In unregistered land, legal leases first. Legal lease is a legal interest. Legal rights bind the world. If it is an equitable lease, then it's an equitable interest capable of entry as a land charge under the Land Charges Act. It is a Class C4 land charge. If it is not entered, it will not be binding on a subsequent purchaser. The case to bear in mind is Midland Bank and Green. What if it is registered land? Well, there are various approaches here. Remember that we're looking at the LRA 2002, and there are 3 categories. The first, of course, deals with those types of registrations under Section 27. We also have Schedule 3 of the LRA, which deals with overriding interests, and we also deal with interests which are entered as a notice under Section 34 or a restriction under Section 43. Well, if you're looking at a Section 27 of the LRA 2002, if you have a legal lease granted for more than 7 years by deed, it must be completed by registration in order to bind. If you're looking, for example, at a legal lease granted for 7 years or less, including, of course, our 3-year oral lease, this will operate as an interest which override. And if, for example, you're looking at an equitable lease, then in those circumstances, it must be that it is registered as a notice or a restriction. The last point then I want to mention and make sure that you have some understanding of is the rule in Walsh and Lonsdale. The rule in Walsh and Lonsdale considers that an equitable lease is as good as a lease. Now, Walsh and Lonsdale is a case from 1882. The landlord and the tenant had entered into a contract for 7 years, for a 7-year lease, and the tenant had gone into possession, but the parties had forgotten to execute the formal deed needed for a valid legal lease. The rent clause in the contract provided that under the lease, the rent should be paid per year, payable in advance at the beginning of each year. The precise figure would depend upon the number of rooms that were let out, the number of looms that were run by the tenant for his business. Despite the absence of a deed granting a legal lease, the landlord demanded the rent in advance in accordance with the contractual term. Indeed, he attempted to recover the rent due by exercising his right of distress. And distress we will consider in the later lecture when we look at leasehold covenants. The tenant claimed that as there was no deed and therefore no proper lease, any rent should be payable in arrears. He therefore claimed an injunction against the action for distress. Well, the court held that the landlord could claim rent in advance. The contract had created an equitable lease which was enforceable between the parties, and the terms of the lease would correspond with the terms of the contract. The tenant holds under the agreement for a lease, and he holds therefore under the same terms in equity as if a lease had been granted, it being a case in which both parties admit that the relief is capable of being given by specific performance. The point, of course, with Walsh and Lonsdale is that it is as between the parties. If there is a third party involved, the courts will not, of course, be as generous because Walsh and Lonsdale does not treat an enforceable agreement for a lease as being good as a lease as regards third parties, only as regards the actual parties to the agreement. And the point to be made, of course, is that you consider privity of contract. Now that ends this session on leases and licenses. I would ask you to join me for the next exciting session on leasehold covenants.